I'm not a lawyer, but as I read the case, this was a felon in possession of a gun with a serial number struck off in concert with another man who had a weapon that I believe was used in the situation. So he was a felon with a gun, and his probation instructed him that he was not to carry that weapon. So I have very strong feelings about that, and I just wanted to say that. I don't think you have to respond, but what I'd really like to talk to you about—
Senator, may I?
Sure, absolutely.
I don't mean to eat up your time or anything, but this is exactly the sort of thing I think I've been trying to convey to members of the committee, which is it's my job to decide these cases without respect to persons. There is the little guy right there. He's a criminal defendant. It's unsympathetic. I understand everything you're saying about it. It's all true. The question is still, does the government have to prove what the law requires of the government or anybody, the big guy? There's no bigger guy than the federal government.
I understand.
And so I'm just trying to follow the plain words of the law. Knowingly be a felon in possession. And the convicting judge told him that he wasn't a felon. And I followed precedent in that case, Senator. The man's in prison because of precedent. But I do wonder—
I accept that is your view,
okay,
and I'd like to move on.
Okay, of course.
It's not my view.
I understand.
He was a felon. So
yes, he was.
Let me go on. I sent some documents not down to you, but over to you yesterday.
Yes.
And I'd like to ask you about one of them, and it has to do about torture. It's labeled at the bottom, DOJ NMG 0143890. I know. And I can send it down to you again if you want to.
No, I've got it right here.
You have notes in the
I've got it right here, yes.
Okay. There's no date on the document, but the document talks about the McCain and Graham amendments to the Detainee Treatment Act, which was before Congress in November and December of '05. And it asks specific questions about the indictment of Jose Padilla, who was indicted on November 22nd, 2005. So the notes must have been on or after November 22nd, '05. Take a look at your handwritten notes on page 2. The document says, has the aggressive interrogation techniques employed by the administration yielded any valuable intelligence? Have they ever stopped a terrorist incident? Examples. Your handwritten note says yes. My question is, what information did you have that the Bush administration's aggressive interrogation techniques were effective?
And Senator, I'm working on 12 years of passage of time here, so my memory is what it is, and it's not great on this, but my recollection—
But you're very young.
Well—
Accept it.
I'll take it. Thank you. I'm not sure my wife entirely agrees with you anymore, Senator, but thank you. That's kind. My recollection of 12 years ago is that that was the position that the clients were telling us. I was a lawyer. My job was as an advocate, and we were dealing with the detainee litigation. That was my involvement.
You actually answered the question.
Yeah.
So you had no personal information that you took the position of your client.
Yes.
And that, because I know a lot about what happened.
I know you do.
That circles around in my brain a little bit, because it seems to me that people who advise have an obligation to find the truth in these situations. And when we learned about what happened on the Intelligence Committee, the Gang of Eight learned earlier. We learned much later. I think it was 2006. We saw, and when we looked into it, we really saw the horrendous nature of what went on. the absence of supervision, the absence of direction, the contracting out to people who, in my view, were not qualified to do what they did. And I think terrible things happen. It's a closed chapter, but it should never again happen. This is America, and it's not what we stand for. So let me move on to something that does trouble me about originalism, if I may. And let me read something. I have a constituent who happens to be the dean of a law school who sent me a question.
Uh-oh.
And I want to present it to you. And here it is. You are a self-professed originalist in your approach to constitutional interpretation. For example, you wrote, and I quote, "Judges should instead strive, if humanly and so imperfectly, to imply the law as it is, focusing backward, not forward, and looking to text, structure, and history to decide what a reasonable reader at the time of the event in question would have understood the law to be." Now, do you agree with Justice Scalia's statements that originalism means there is no protection for women or gays and lesbians under the Equal Protection Law because this was not the intent or understanding of those who drafted the 14th Amendment in 1868?
Senator, first of all, a good judge starts with precedent and doesn't reinvent the wheel. So to the extent there are decisions on those topics, and there are, a good judge respects precedent. That's the first point. Second point I'd make is it would be a mistake to suggest that originalism turns on the secret intentions of the drafters of the language of the law. The point of originalism, textualism, whatever label you want to put on it, what a good judge always strives to do, and I think we all do, is strive to understand what the words on the page mean, not import words that come from us, but apply what you, the people's representatives, the lawmakers, have done. And so when it comes to equal protection of the laws, for example, it matters not a whit that some of the drafters of the 14th Amendment were racists, because they were, or sexist, because they were. The law they drafted promises equal protection of the laws to all persons. That's what they wrote. And the original meaning of those words, John Marshall Harlan captured them in his dissent in Plessy. And equal protection of the laws does not mean separate in advancing one particular race or gender. It means equal. And as I said yesterday, I think that guarantee, equal protection of the laws guarantee, the 14th Amendment, that it took a civil war for this country to win, is maybe the most radical guarantee in all of the Constitution and it may be all of human history. It's a fantastic thing. And that's why it's chiseled in Vermont marble above the entrance to the Supreme Court of the United States.
Now, I understand that, but here's what is hard, and let me be very personal about it because this is important. I have sentenced women to state prison for committing abortion. I was a member when California had an indeterminate sentence law, actually the youngest in the country. And I know what life was like. You have 2 daughters.
I do.
I am one of 3 daughters. And I know what life was like. I have heard of young women killing themselves. I've heard of passing the plate in colleges so that a young woman could go to Tijuana to have an abortion. I read a letter from a woman who's going to be in the audience tomorrow of how trying to get pregnant, finding that the fetus was catastrophic and having just a terrible time. So the law has finally progressed that we now have the right to vote. That took a long time. We are still fighting work, and it goes on and on. And as women take their place in the workplace, in society, we could have had a woman as president. Life changes. And the originalism that the days when the Constitution was written project to me don't bring somebody forward, they bring them backward. In terms of rights that women did not have, they were not looked at as equal. As a matter of fact, we couldn't even get ratified a constitutional amendment, very simple, equality under the law should not be abridged on account of sex. That was the Equal Rights Amendment. And the time was extended from 3 years to give it more time, and they could not get the number of states to approve it. So if one looks at originalism in my context, which is real life, I want your two daughters to have every opportunity they possibly could have, be treated equal, be able to control their own bodies in concert with their religion, their doctor, whatever it may be, and not be conscribed to a lesser fate because the law is interpreted in a backward sense. Does that make sense to you?
Senator, I understand your concern and I share it. I come from a family of strong women. My two teenage daughters, you're right. I want every opportunity for them that a young man has. I have a strong wife. Anyone who knows her knows that. My mother.
But you are pivotal in this.
And Senator, I am daunted sitting here under the lights at the prospect of what's to come if I'm so fortunate to be confirmed. And I'm daunted by the job I currently hold. And I take that trust very seriously. Is looking to return us to horse and buggy days. We're trying to interpret the law faithfully, taking principles that are enduring in a Constitution that was meant to last ages, and apply it and interpret it to today's problems, And I think if you look at a number of cases where the court has applied what might be labeled by some as originalism, you will see, for example, in Kylo, the search of a home with a heat-seeking device. The court looked back to find out would that be considered an unreasonable search. That technology didn't exist, of course. But would something like that have been considered an unreasonable search at the time of the Fourth Amendment's adoption? And found it's essentially equivalent to a peeping Tom. And of course that would have been considered an unreasonable search by the government. And so a heat-seeking device, thermal imaging, is also a search of a home. That's how we use neutral principles, the law, to apply it to current realities, not to drag us back to a past, but to move forward together as judges applying the law neutrally.
Here's the problem. I've been through this before. I've been through 6 hearings. I listened to Senator Specter when he was chairman of this committee tell the Chief Justice, well, you have described super precedent. We talked about precedent. And what's happened is every Republican-appointed judge has gone back and is a no vote. So how does one look at you? And we've talked about precedent. For the life of me, I really don't know when you're there what you're going to do with it. And it's so, and as you say, this isn't text, this is real life. And young women take everything for granted today. And all of that could be struck out with one decision.
Senator, all I can do is, I can't promise you how I'd rule in a particular case. That would be deeply wrong to sit here at a confirmation table. And I think we agree on that it would be a violation of the independent judiciary for a nominee to a court to make a promise on any case in order to win confirmation.
No, I don't expect you to.
I know you don't, and I'm really grateful for that. I know you appreciate my position. All I can promise you is that I will exercise the care and consideration, due precedent, that a good judge is supposed to. And I've written a book on it. This is not something that is just words in a room. This is years of toil in putting together a mainstream consensus view on what precedent is and the law of it, with 12 judges appointed by presidents from both sides, with a forward by Justice Breyer. And I didn't expect anyone to ever read it. I think a few people have read it now, still not that many. But that's my life's work, that sort of thing. I care about the law. I care deeply about the law and an independent judiciary and following the rules of the law. And that's what commitment I can make to you. I can't promise you more, and I can't guarantee you any less.
Well, what worries me is you have been very much able to avoid any specificity, like no one I have ever seen before. And that's a virtue, I don't know. But for us on this side, knowing where you stand on major questions of the day is really important to a vote aye. And so that's why we press and press and press. It's very hard because you mentioned that the number of cases you sat on and the percent that was unanimous, I think, was 97%, you said. And so we realize that these are few cases on which the distinction is made, and it's hard to make that distinction. So, you know, when one sees a lot in this country, and I just want to say this, for me, I sat on 5,000 cases. These were women convicted of felonies in the state of California. I did it for 6 years. And so I saw the inside of this whole issue. Reasons why I feel so strongly, particularly, let me ask you another area, assisted suicide.
Sure.
You make the statement that there is no justification for having anything to do with the end of someone's life, encouraging the end of life. Well, California just passed an End-of-Life Options Act that takes a number, I think 3 doctors. I, in my life, have seen people die horrible deaths, family, of cancer, when there was no hope. And my father begging me, stop this, Dianne, I'm dying. You know, my father was a professor of surgery. Now, trying to save him. So there are times you can't, and the suffering becomes so pronounced. I just went through this with a close friend, that this is real, and it's very hard. So tell us what your position is in the situation with California's End-of-Life Option Act, as well as what you have said on assisted suicide.
And Senator, this is something I can speak about because I've written about it, and I'm delighted to talk about my record. I wrote a book in my capacity as a commentator. It was my doctoral dissertation, essentially, before I became a judge. I'd have to tell you, as a judge, put that aside, and we talked about that. But I'll talk to you about what I wrote in the book, because I think that's fair. What I wrote in the book was, I agree with the Supreme Court in the Cruzan decision that refusing treatment, your father, we've all been through it with family. My heart goes out to you.
Yeah, well.
It does. And I've been there with my dad. Okay. And others. And at some point, you want to be left alone. Enough with the poking and the prodding. I want to go home and die in my own bed in the arms of my family. And the Supreme Court recognized in Cruzan that that's a right in common law, to be free from assault and battery effectively, and assumed that there was a constitutional dimension to that. I agree.
Supposing you cannot handle the pain, and you know that it's irreconcilable.
And Senator, the position I took on the book on that was anything necessary to alleviate pain would be appropriate and acceptable, even if it caused death, not intentionally, but knowingly. Okay? I drew a line between intent and knowing. Okay? And I've been there. I have been there.